Why would you be with somebody who you think is cheating on you, who has friends in categories that you feel you have to defend yourself with a knife by placing a knife on her, who then tells you it's a sugar daddy, and to top it all off, she really doesn't want you around your own child? Why would you be with that person? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
My name is Daniel Morales.
All right, in just one moment. Is the interpreter ready?
I'm ready, Your Honor.
With the interpreter?
Yes.
Yes.
All right, and we're off the record, and what is your case about?
Ezekiel Chavez, it's 6 months to do no application.
All right, I'm so sorry. Let me finish this hearing and then I'll take you up next.
We're ready.
All right, thank you.
Judge.
Yes,
Um,
we're back on the record.
Mr. Morales, you've heard all of the testimony prior to this, correct?
Yes, sir.
And you've had that discussion about the need for structure, correct?
Yes, sir.
But you recognize that if this judge were to look kindly on the probation application, that none of that would matter if you do not have a desire for change.
Yes, sir. I understand.
And are you asking the court to grant you probation?
Yes, I am.
And if granted probation, do you understand that there's a multitude of things that you could do that could get you sent to jail for up to 20 years?
Yes, sir. I understand.
You also understand that we know it was a back and forth with the alleged victim. Okay, correct?
Yes, sir.
But you understand that there's no more contact with that person.
There's no more contact.
Y'all don't have any children together,
No.
but you do have a child.
Yes, sir.
And part of when your grandmother when I was talking to her, but also on your urging, a lot of this is because you don't want your son to be dealing with what you're dealing with right now, correct?
Yes, sir.
But you recognize that you need to actually have some training and accountability to get you to a place where your child can inherit your recovery.
Yes, sir.
So last question I would have for you is, what does surrender mean to you?
I think surrender, look to me, I think it means change.
You're willing to give up these past ways of reacting to situations you don't like.
Yes, sir.
And you're willing to accept instructions on how to respond to things you may or may not like, correct?
Yeah, I'm willing to change so I can do better for myself, not only for myself, for my son.
I will pass it.
All right, you may proceed.
Mr. Morales, how old is your son?
It's 4, about to be 5.
Okay. When your son grows up, if he gets involved in an altercation where he assaults his girlfriend, for example, do you feel like he should be held accountable for doing so? What about if it's his mother? If he has assaulted his mother, you think he should be held accountable? Do you think if he threatens someone's life, you think he should be held accountable? I'll pass the witness, Ryan.
Any further questions?
Nothing further, judges.
I have a few questions. Any objections?
No objection from the state.
All right. So,
And what for prior judge, we would, in terms of the stipulations that we had tendered to the court, probably should have done this before. Believe those are the same steps that we signed previously with the amendments that we had. Okay.
all right. So this is my concern and what I'm looking at. You have a case from September 16, 2024 with this complainant, and that's pointing a deadly weapon at her, namely a knife. And then you have a case from December 8, 2024, and that's another assaultive behavior against the same complainant, and this time choking her. And all of this is over your breakfast not having ketchup. So number one, what breakfast that you wanted did not have ketchup? This is just for me to know.
The only reason why I brought that up is because I was getting cheated on and
No. So here's the thing. When people cheat on people, you have two choices. One, you forgive them and accept that they're cheating on you. And if they deny it, you either say, okay, they've denied it, I'm gonna let it go. But your choices are either you stay and you accept it or you move on. So back to this ketchup business. So what breakfast were you having that you were so upset that there was no ketchup?
She was upset she didn't have any, and I told her.
No, this is what, let me just tell you what the steps read. It says they spoke to the complainant. The complainant stated that they had been arguing since last night. You struck her on the face. And let me see, where is it? Where you told her to let that BAN get ketchup for her.
Yes.
So this was over ketchup. And it was you who wanted the ketchup.
No, I
It says that you wanted ketchup. So what breakfast, was this eggs? It says the complainant stated today they argued because she made breakfast and they did not have ketchup.
I don't eat ketchup with my eggs. She does. And she told me that she didn't have any, so I told her to tell him to go buy it for her.
Yeah. And so how does this turn into you grabbing a knife?
Because she has people knocking at her door and I couldn't defend myself.
Okay, so that's in September. So you grab a knife in September because you can't defend yourself because she has people in whatever category you're talking about. So then the question becomes, if you think she's cheating in September and you're telling her to tell some other guy to get some ketchup for her eggs, and you pull a knife on her because you're afraid of other people she has, then why are you with her in December?
Because when I got out, she told me that she wanted to take me back. And
But no, why would you want to go back? She's cheating on you. She has these other people in some category that you're afraid of, and you have to pull a knife on her. So why would you even go back to her?
because she told me it was just a sugar daddy that is just some old guy who gives her money. I believe her.
Mhm.
And
So then we come to the December case. And the December case involves choking. And it says that that she didn't immediately report because you're controlling and overhear her conversations and read her text messages. So it says that she contacted the babysitter to see if the babysitter could come by. And when the babysitter came by, she let the babysitter know what was going on. So I'm assuming this complainant you were with has children.
yes, she has children.
And when you say children, how many children?
She has two, a daughter and a son.
And what are their ages?
I think her daughter was 2 and her son was 6.
2 and 6?
Yes.
All right, so you all are having these children see violence in the household, 2 and 6. You think she's cheating? She says she's not. Then she tells you it's a sugar daddy, and you're okay with that, which means you're okay with her doing whatever she does to get money, according to you, from a sugar daddy. And where was your child in all of this? This child that now you need to be there for, and you want them to see different things. Where were they?
I was still seeing him every day, and she didn't like it because she thought I was talking to the mother of my child.
And that's the other thing. Why would you be with somebody who you think is cheating on you, who has friends in categories that you feel you have to defend yourself with a knife by placing a knife on her, who then tells you it's a sugar daddy, and to top it all off, she really doesn't want you around your own child? Why would you be with that person?
Because I made a mistake, and
Nope, these are choices. These are not mistakes.
yes, it was my choice, and my choice turned into a mistake.
All right. And what's with this tattoo on the face?
It used to say her name, but I covered it up to my brother who passed away.
All right. So, and then you get her name tatted on your face. So you get her name tatted on your face. Don't even have your son's name tatted on your face.
No, I have it on.
As a side note, this is what I always tell people. When you're getting tattoos of people's names, these are your best options. Your mother, because your mother's supposed to always love you, and your children. Getting names of females or males, never a good idea. And what's with this San Antonio tattoo? Do you love San Antonio that much that you need that tattoo? What's that about?
I was born here.
Oh, a lot of people are born here, but they don't have a San Antonio. How many people are born here were you born do you have a San Antonio
I
tattoo?
have no tattoo.
I don't either, Judge.
So what's that really
I love
about?
San
I
Antonio.
recently started getting tattoos, so I I like how tattoos are.
And then it says 210.
Yes.
Yeah, what's going on with the tattoo?
Like I said, it's just where I'm from.
Alrighty, is that your story? You know, you stick to your story.
Yes, ma'am.
What's that tattoo about?
Like I said, it's just where I'm from.
Alrighty.
Well, I don't know, for me.
Oh, no. You can ask whatever questions you want to ask counsel.
The environment in which you were raised, I think you probably get to what the court may be alluding to.
Look, are you a gang member?
No,
So why do you have that tattoo?
And if I could,
Sure.
and if you did, if it would be more along the lines of like thousands of people in San Antonio are posers. For example, there's thousands of people in San Antonio who unknowingly have, for example, the Michael Jordan Jumpman design on their arms because they think it's cool around other people, not understanding what connotation that has with actual gang members who are danger to this society and probably shouldn't be here. You understand that, but as basically a kid, how old were you when you got this tattoo?
I got it about a year ago.
Okay, so how old were you?
I was 21.
Okay, so as a 21-year-old, not fully understanding the ramifications of certain things, you personally just thought it was cool. It had nothing to do with you being a gang member.
No, I just got it because I started getting tattoos.
Okay.
Any other questions?
Stay just argument.
All right. All right. In each of the cases, the court does, I don't think you're a good candidate for probation. Unless the complainant is going to walk in here and says that she wants you to have probation, it's not happening. I'm going to find you guilty in each cause number. You all have,
Your Honor, were we able to make the argument or support just?
I'm finding him guilty. You all can make an argument as it relates to the cap. All right, so it's a cap of 5. The court will hear argument.
In support of Kappa 5, Your Honor, the defendant has a long violent history. Essentially, since 2020, he's picked up violent offenses. In 2020, he got a cleansing assault. I was unable, since it's a city offense, to determine the facts of it, but I do know that he served 5 months deferred. In 2021, he had a misdemeanor, ABI family violence, that he did an 8-day JSAT on. The following year, 2022, he picks up another Class C assault that he does 5 months probation on. 2023, a terroristic threat, family violence, that he does 8 months deferred adjudication on. And then these two, all within the same year that we're here for today. There are actually 3 cases, one's being TIC as part of the plea, but I feel that because of this defendant's long violent history, he is not a candidate for probation and that prison would be the most appropriate option for him.
All right, defense.
Your Honor, we would ask the court to consider the lower end of the cap on this case, which is 2 years. He's expressed a lot of contrition. Of course, in these cases, there are always, but what we would say in terms of the complainant, we guess we would renew this motion to the court. My understanding is that the state, that the complainant has moved out of state and that they weren't here. So if the court would give us time to possibly get an investigator to try to bring her in to start, at least see if she has an issue with probation, we would ask the court's leave to possibly do so with the reset. But if the court is not so inclined to allow for the state to try to reach her or for us to reach her, we would ask the court to come in on the lower end of the range here. He understands that there were things he could have done differently. We're also very, very careful in making sure that we're not blaming the quote unquote victim in any way in these situations. But what we will say is that she was a much older than the defendant. There was a significant amount of manipulation, but again, which is why we presented that evidence to the court. We believe that he didn't have the background to be able to develop the ability to react in a way that would be within the guise of the law, as opposed to ways that could be construed as criminal offenses. Given his age, given the support structure that he has, we would ask the court to come in we would ask the court to give him a sentence of 2 years on this case. And we would also ask the court if the court would be willing to maintain jurisdiction over the case if the court were inclined to give him anything over 2 years.
All right. And each cause number, the court, as previously stated, is finding you guilty. The court will sentence you to 5 years in the prison, give you credit for any time served. There's a $1,500 fine, time and money to run concurrent. There's an affirmative finding of family violence in each cause number. There's to be no contact with the complainant. Taking consideration 2025 CR 002680. There's to be no unsupervised contact with minors. There's to be no residing with any household that has minors. And our request the therapeutic community in each cause number. In each cause number, did you review the documents entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes,
All right, because these are plea bargain agreements, because I followed your plea bargain agreements, because you waive your right to appeal, you do not have your court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
yes, ma'am.
All right, we can go off the record. Counsel, I'll retain jurisdiction. We'll see how he does.
Yes, sir.
All right, thank you. Where are we on this case?
Okay, so today I think we're set for discovery hearing,
Mhm.
and I think we're in pretty good shape on discovery.
Okay,
We have conferred, and I guess probably we'll need a plea deadline and trial setting. I have a motion to suppress. I'll keep filing.
all
But
right.
the other thing is that we had appeared, I think, on a bond reduction that I hadn't filed yet last time.
Mhm.
The court asked for some follow-up information.
Yeah.
I did file it this morning. But we have, the bond set at 75,000.
Mhm.
We're asking for a reduction to 40,000. And with conditions of GPS and to go directly, we're trying to find a place for him, either a Salvation Army 180-day residential men's program or Haven for Hope.
All right, so let's do this.
Okay.
Your Honor,
Because-
Your Honor,
Yes.
can I speak please before you
Sure.
make this statement, Your Honor?
Mhm.
This is what my teachers on what I'm asking the court, Your Honor. I have mental issues like I spoke with you the last time,
Hold on. I don't want
the
you to-
bar reduction, I'm not talking about. the
Okay,
case.
all right.
Okay, so let me explain something to you. All right, so before you even say anything, because this may address the entire issue. Number one, my concern, and I noted it, that there's maybe some mental health.
Yes,
Then we have an issue with he has no place to stay.
correct.
So those are the court's two concerns. Your attorney has just said that she's looking into some certain places where maybe you can stay. What I can tell you is, it is best for you that she has the information. Yes, he can stay here or he can stay there. Because putting you on GPS, guess what? They're not gonna let you have GPS if you don't have a place to stay.
No, that's not what I'm saying. You was hitting the nose from the beginning. This is what I'm saying. It's pertaining to my place to stay or what I'm asking the courts. If it's possible, instead of giving me a bond reduction, could you take this into consideration as placing me as, because one of the places that my social worker got with me on was the Salvation Army because they have a mental program.
Mhm.
And I would like to, since I'm a candidate for it, I would like to be a full participant in that until pending trial or whatever situation is, to where I will have a place to stay, I will have my mental issues taken care of at the same time. I'm not asking to get out on bond to roam freely. I'm asking.
No, I understand
I'm
that.
asking
So
for
what you're
help,
asking the court is not for a reduction, you're asking for a PR bond?
something, but this, I wanna get placed in the facility to where I can receive treatment because of my mental issues, and like I told you the last. That's all I'm asking the
All
court.
right, so this is
please.
what I want you to do. I want you to internalize what I'm saying, because I think we may be saying the same thing, but we're just crossing each
Yeah, but
other.
I just don't want you to think that I just wanna get a bond reduction to get out on the GPS monitor. I'm asking the courts for help on a mental state.
No, and what I'm telling you is, that's what I'm trying to do, and that's what your attorney is telling me. So you're saying you may have placement, a place to stay. Well, I'm going to need verification of that. And your attorney says that she's going to give me the verification of that if that's the case. So what I'm going to do, counsel, if I'm going to reset this for a plea deadline date,
Okay,
but if you have a place for him to stay, if you have that available tomorrow, just come back to court. We'll have a hearing. They'll have him brought over tomorrow.
okay.
So-
The logistics of it is where we kind of get snagged up because it's like, well, he has to get released on bond first and then we can make arrangements, you know, it's,
Oh, no, I think if you can get somebody here from the Salvation Army, I think we can work on that. So,
Okay.
and they can appear by Zoom.
okay,
So what I'm gonna do is I'm gonna set this and I want you to hear what I'm saying, okay? So your plea deadline date is gonna be May 29th.
I'll be out of town that day,
Oh.
any other day. That week I'll be gone, but then.
Oh, okay. Do you want to do it? Otherwise, I'd have to put you in June. Are you okay with June then?
Yes, or I don't mind coming earlier.
I can put you then for May 22nd.
I can do that.
All right, Ms. Ferguson, plea deadline date is May 22nd. So that's your plea deadline date. Now, this issue with your bond and your residency, your attorney can come back any day.
I know you
If she
said
got-
that the last time.
Yes, so-
I don't mean to cut you short,
Yeah.
cause she didn't fully get it understood, cause I heard exactly what you said the last time
Mhm.
about when you came the first time with the
Uh-huh.
harm reduction thing. I just wanted to get it understood that she said, when you say anytime, literally, you mean anytime, literally?
No, not literally. It has to be coordinated with the court
That's what I'm saying.
coordinator and the, court. No, it's not. I can't just walk in.
No.
No.
So what will end up happening, for example, is she's able to call them today and they say, yes, we have a place for him to stay. Then all she has to do is contact the coordinator and say, can I come back for tomorrow? Or can I come back on Wednesday or Thursday or whatever day it is? We'll set it, we'll bring you back and she'll have the information for you. So it'll be before the deadline, the plea deadline date, okay? All right. Do you have any questions?
Cause the thing is, ma'am, I'm just trying to get help, treatment until we formally resolve this situation we're dealing with this criminal case, ma'am. That's all I'm asking is for help.
No, I understand, and we're trying to do that, but part of my job as a judge is also to make sure that the community is protected and make sure that you get what you need, your treatment. And so she's trying to make sure that she verifies that there's a place. If she can get a hold of your case manager and the Salvation Army,
Well, it's someone from MAG, Your Honor. It's not an independent case.
Okay, so
But
if they,
it's just the logistics of it, and because funding has shifted and things have shifted, it's gotten a little harder to figure out, but, and the wait lists are longer.
okay,
Okay, we'll get that information together. She went back to her office to try to get some more.
He didn't ask to be free, he asked for help. The judge listened, paused, and made one thing clear. Mental health matters, but structure matters more. No shortcuts, no excuses. Treatment only works if it's real. So the court asked the hard question. Are you ready to change or just trying to leave jail? Justice isn't always about punishment. Sometimes it's about accountability, like, share, and follow for real courtroom moments.
and are you Mr. Chavez?
Yes.
All right, we have an interpreter here today. If you could raise your right hand for me, please. Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand if you'll state your name for the record.
Cesar Chavez, license number 2203.
All right, counsel, do you speak Spanish?
Yes, Your Honor.
And do you speak it fluently?
Yes, Your Honor.
And were you able to explain all of these documents to your client in Spanish?
Yes, Your Honor.
And counsel, have you received all discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Chavez, all of the documents I'm reviewing with you are in English. Were those documents explained to you in Spanish?
Sí. Yes.
Did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
All right, Mr. Chavez, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Did you understand you're charged with terroristic threat against a peace officer or judge as a state jail felony? Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you were giving up those rights. Did you understand?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Chavez, has anyone threatened you, forced you, or placed you in fear to get you to enter this plea?
No.
Has anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
And are you a U.S. citizen?
No. No.
And for the record, this is cause number 2025 CR 000406. Counsel, with regards to his citizenship, has an attorney spoken to him about the impact this plea will have on his immigration status?
Yes, Sean, if I may briefly, we requested the MAC office contact him. Justin Tullius did meet with him. He provided me an updated status report as to his immigration status. I've conveyed to him that there is a high likelihood he will get deported, as well as if once he's deported, he may be denied reentry. Knowing all that, he is ready to proceed.
All right, Mr. Chavez, do you understand by entering into this plea agreement, you will be deported and are not allowed reentry into the United States?
Yes.
Knowing that, do you still wish to continue with this plea?
Yes.
And do you understand that you will also be denied naturalization?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at 180 days in the state jail facility. There are no applications. The state will take in consideration 2025 CR 000405. Did you understand that to be the plea?
Yes.
Defense, is that the plea?
Yes, Sean.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Yes, Your Honor. State Exhibit number 1 with all of its attachments.
No objection, Your Honor.
All right, state, you may be excused.
Thank you.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find that there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
He just wants the court to know that he does accept responsibility.
All right, the court, as previously stated, is finding you guilty. The court will sentence you to 180 days in the state jail facility, give you credit for any time served. Take in consideration 2025 CR 0004005. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, good luck to you. Thank you.
Yes.
And I believe the dismissal.
Substantive detail.
All right, thank you.
Okay, thank you, Judge.
You're welcome. Who's here on Christian Allen Garcia?
Sorry, Judge, I had some other cases up in front of you. I didn't expect him to come first.
All right, so do you have all the discovery?
We don't, Judge. That's the reason we've been getting rescheduled. What
All right.
happened is there's a juvenile that was charged with certain offenses, my client. We're trying to get the files on, and as you know, those files are in another department. They're not readily accessible to me. There are several aggravated robberies. I'm trying to.
Oh, just 1 second.
I'll let him finish, but I just need to step away to speak with
Sure.
Mr. Garrett.
And so because the juvenile had so many cases, they actually resolved his matters without taking into consideration the cases my client has pending in your court. So we're trying to recover where's the discovery on those cases so that I can have access to it.
And who is the juvenile? Is that the co-defendant
Or the
or?
co-defendant, yes, Judge. We would suggest the main actor in the case.
Okay,
Judge, so regarding the juvenile co-defendant, we reached out to the juvenile division of our office. They represented to us that because the juvenile also had a large amount of cases, that they worked out cases that were actually charged in the case at the time when they reached the plea deal. The cases that are involving this defendant were not actually formally charged, and they never received any evidence for them, and they were resolved with the plea deal. And so there's no additional evidence at juvenile pending.
Well, Judge, that doesn't mean they don't exist. In fact, the state suggesting that the investigating officers just gave up working on the files and never submitted them. They'll tell us that, that's fine, but I still want that evidence.
What evidence specifically are you requesting? Because they wouldn't have just ceased investigating it, they would have turned it in under this defendant's case. So if you
Well-
point to something specific that you need, I can reach out to them, but just saying a blanket when I've already turned over everything that I have is just not feasible.
Well, and I understand that, Judge, and I'm not trying to be difficult, but this juvenile was charged with over 10 aggravated robberies, maybe as many as 15 or 20, right? He's a serial aggravated robber. My client was only charged in one day. And we believe we may be able to raise a duress defense and other things like that. So the big picture of what happened with that juvenile and what he was up to and what he did would be very enlightening for the jury. And it could be even exculpatory in terms of me being able to prepare my duress defense.
all right, so who's the prosecutor who handled that case? And is that the person you're reaching out to, that prosecutor?
We reached out to the investigator and the prosecutor, I think. You just give us that.
Sure.
I would, Judge, I'm sorry, it's been a while since
No,
I
no.
contacted them, but I'd have to check my emails real quick.
All right.
If I may.
And the reason why I'm asking, because then this is what I suggest we do. If that prosecutor is over in juvenile, still in juvenile, then of course they can't be here. They can appear by Zoom. So we can get to the bottom of the discovery and what they have. So I'm going to give you all another set date for discovery. And if that prosecutor, whoever they are, if they are in still in juvenile, they have to be over there. That's on probate. See if they can Zoom in, and then we can find out what discovery they have, what they don't have, and who touched the file, who did not touch the file. All right?
Yes, sir.
All right, so do y'all think there's enough time if I set it for May 27th or May 29th?
That should be sufficient, whichever day.
Either one? May 27th or May 29th?
I would great, Judge.
All right, Norma, this is coming back for May 29th.
Judge, I have another motion on Mr. Garcia, if I may.
What is that motion?
One of his charges is evading in a vehicle. He has a condition of no driving.
Mhm.
It's been a year since the offense date. He's been in full compliance with the court's orders. It's becoming difficult for him to get to work and do the things kind of he needs to do with his parents constantly having to chauffeur him around. And they're here today also to testify about what the essential need is. But basically, he wants the no driving restriction removed, at least enough for him to go to work and come back home.
State, do you have objections to him being allowed to drive to and from work?
Judge, if I could just have a minute to.
Sure. After this case, it's going to be Washington, Galvan, Alta Marino, and Moore and Rivera.
Can you sneak in Berlanga too?
Huh?
Can you sneak in Berlanga too?
I don't know if it's up here. If it's up here.
Actually, it was the first one I asked her this morning.
Okay.
He must have got second wrong.
Judge, so I don't necessarily have an objection to him being able to drive because there's been no pretrial violations, but I just would request a curfew.
All right, so if you all figure out what the curfew will be, and I'll allow him to be able to drive to and from work.
Okay, Judge, I'll work on that order while I
Okay.
step back and I'll bring it back.
All right, thank you.
I excuse my client.
Yes, well, 2025 CR 00495, State versus Mason, Washington. Could I have parties announced for the record for the state?
Ashley Jones.
Defense.
Christine McDonald for Mr. Washington.
And are you Mr. Washington?
Yes.
So have you all changed your plea bargaining agreement or no?
Your Honor, we have not come to a resolution at this time. I've asked the state to hold the 4 years TDC offer open until the next setting. Like at this time, Your Honor, my client is requesting a trial setting. At our previous hearing, Your Honor, you did grant us funds for an expert.
Mhm.
I did tender my copy of a specific request for discovery to the state at that time. I re-forwarded it today. We are still waiting on some additional discovery that our DNA expert is requesting, Judge. But at this time, we did not come to a resolution and are requesting a trial setting, Your Honor.
All right, are you ready for trial?
Your Honor, I'm still working with my expert and they have not disclosed this additional discovery that we discussed last time, Judge. And that might be because we did have a plea worked out, which did not.
All right.
We weren't able to follow through on.
Did you all review the defendant's discovery request?
We did, Your Honor, and I made the request this morning and they have already uploaded what the defense has requested. However, I do know that there's a 24-hour delay on when they can see that information.
All right, so you have no objections to the discovery that's being requested?
Correct, Your Honor.
All right, so the court will grant the discovery request. And this will be set for jury trial. And you said it'll be uploaded when?
It's already uploaded, Your Honor, but there's just a delay in actually view the material
All right, and when will they be able to?
tomorrow,
Okay,
my understanding.
all right, I'll set this for jury trial on May 13th.
Well, Judge, if we can request a little bit more time so my expert can have a chance to review everything. I did let him know that we'd be getting in contact with him because we were hoping that we had resolved this case, Your Honor. So if I can have time to work with this expert so he can have enough time to.
The courtroom was ready for a deal, but everything changed when the defense demanded a trial. The judge learned the DNA evidence had not been fully reviewed, the expert still needed time, and key discovery was incomplete. Instead of rushing a decision, the judge pushed the trial date back, making one thing clear. When someone's freedom is on the line, guesses aren't enough. Only facts matter. Now the truth will be tested in front of a jury. What do you think? Did the judge make the right call? Like, share, and follow for more real courtroom drama.